Thank you, Mr. Speaker. Merci, Monsieur le Président.
Thank you, Mr. Speaker.
Aujourd'hui,
It is an honour for me to rise today and speak to the amendments to Bill C-46, an act to amend the Criminal Code and to make consequential amendments to other acts.
Benign title. It doesn't tell us what we're debating. We're debating a bill that will deal with, I think all of us in this House can agree, the critical issue of doing whatever we can to reduce the loss of life and accidents that are just so damaging to society, that are caused by people who drink and drive or drive under the influence of other intoxicants. So the bill deals with both alcohol and drug abuse, substance abuse, and getting behind the wheel of a car. The statistics are, and we all know them, but they are absolutely devastating to imagine. As Mothers Against Drunk Driving, a group I support, the Mothers Against Drunk Driving's estimate is that in Canada every day, on average, 4 people are killed in automobile crashes. If we had the kind of attention to immediate review of auto crashes and people killed in auto crashes that we do when we're traveling in public transit, such as in an airplane, we would be on a daily basis made aware that our publicly accepted system of transport is lethal. We have a society built around the car. Our transportation networks are built around the car. We don't seem to mind the idea that our everyday method of getting from A to B involves a significant risk of death. We take it as something that's just one of those risks we live with. A car is a very powerful and potentially killing machine. In 2012, the totals were 2,546 Canadians who died in automobile crashes. But now, to the point of today's bill, 58.8% of those crashes involved a driver who had had at least some measurable intoxicant in their system. In 2015, this is not just those, this is beyond those accidents which involve fatalities, but a total of over 17,000 impaired driving incidents happened across Canada in 2012, rather in 2015. 2015, over 72,000 impaired driving incidents across Canada. What's interesting, again, the statistics reflect that this is a significant improvement. That's 65% fewer incidents than in 1986. So the measures that we are taking make a difference. The awareness that drinking and driving is not acceptable, blood alcohol levels, and roadside screening make a difference. There's no question but that we want to support measures that will ensure that Canadians who have had any measurable intoxicants don't get behind the wheel of a car, that their friends stop them, that the guy at the bar stops them, and that their own concern that they will be hit with serious penalties and jail time will stop them. Now, to this bill and the reasons that I've submitted the amendments, I support Bill C-46. Unlike some of the experts I'm going to mention to you, even unamended, I will vote for Bill C-46. But here at report stage, I wanted to raise again the concerns. There are significant concerns from the Criminal Lawyers Association, as well as from the Civil Liberties Associations, that the bill will go too far and will end up being challenged in the court. And that's because it involves, without the proper constraints, random breath testing as opposed to selective breath testing. And I've gone through the evidence very carefully. It's clear there are a lot of statistics that say when this jurisdiction or that jurisdiction brought in random breath testing, drunk driving incidents went down. To that, the people who study this say we don't actually have good numbers that compare the results between selective breath testing and random breath testing in order to conclude that you couldn't have gotten the same results with selective breath testing. So again, what's the difference? Well, if you're having a selective breath testing, you set up a roadside check, you stop every driver, you have a look at every driver at a stationary driver vehicle test. We've seen roadside testing set up in different locations, particularly on evenings when people are more likely to have been out having something to drink or ingesting any substance that's an intoxicant before driving. The roadside testing is very effective. Selective testing is effective. This law would go farther, and this is where the various legal societies that I've mentioned are concerned. Let me quote from the brief of the Criminal Lawyers Association submitted to the committee back in September. What they say is, quote, "We are deeply concerned by the new random breath testing regime. Increasing police powers do not come without societal costs. The experience of carding or street checks is instructive on how the exercise of police authority can disproportionately affect visible minorities. Bill C-46 amounts to carding while in a car. It will inevitably, disproportionately be employed against minority or marginalized communities," close quote. A policy expert with the Canadian Centre on Substance Abuse, Doug Byrnes, was even more blunt. Quote, he said, "There is nothing truly random about random breath testing. The term random is used in place of the more accurate and contentious descriptors, such as arbitrary or capricious," close quote. The Canadian Civil Liberties Association went on to say, "A full review of the evidence over 23 studies does not provide convincing evidence that implementing random breath testing will necessarily have a greater impact on drinking and driving than Canada's current selective breath testing system." So my concerns are twofold. We should never pass legislation in this House that has a good public purpose, and I don't think any of us for 1 second will deny the importance of the public purpose, that has a significant risk of being derailed in the courts. Looking at the evidence that was put before the Justice Committee, I think this bill has a significant risk of being derailed in the courts. We should likewise do whatever we can to moderate the impacts of increased police powers and the risk of randomness. I've been wondering if I should share this story with my colleagues in Parliament, but I think I will. More than 40 years ago, living in a small village on Cape Breton Island, we had very limited RCMP protection. There was one detachment. My brother's younger than I am, and in those days he had long hair. It was unusual in this particular community to have long hair, and every single time he went anywhere, he was pulled over by the RCMP. As I said, we had very limited RCMP protection. It was very hard to get the RCMP when you were, for instance, in the middle of a store robbery, which also occurred in my family business. And I love the RCMP, they're wonderful, but I know for a fact that there is such a thing as selectively pulling people over and over and over again and never finding anything. It's a form of harassment. So for marginalized communities within Canada, I'm very concerned about discriminatory and preferential random searches of particular marginalized groups. We know this happens. You can look at the statistics of who is in our prisons, and overwhelmingly it is people of color, Indigenous peoples. It is not reflective of society as a whole. And we know this about carding and urban police forces. So it's clear to me that there's going to be an increased problem for marginalized communities, a sense of being harassed. So at least, as parliamentarians, I commend to you my Second Amendment, which when this process is reported back to Parliament, that we have, and this is my amendment that you'll find to amend Clause 31.1, that there be an evaluation of whether the provisions have resulted in differential impacts on particular groups likely to be targeted based on prohibited grounds of discrimination, and prepare that report to set that out for us. This will be a test for us as a society. I have no doubt this bill will pass unamended. I'm making an effort here because I'd like us to think about what happens when random breath testing isn't random. And as much as the societal purpose is overwhelmingly in the right direction, get people who are drinking or intoxicated off the roads. Don't let them get behind the wheel of a car. But in this case, think twice and make the bill constitutional before we pass it. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Langley Aldergrove.
Thank you, Mr. Speaker. I was honoured to sit on the Justice Committee on C-46, and was actually quite shocked at the position of members across the way from the Liberal Party that they believed that the current sentencing, mandatory, the minimums of a $1,000 fine for driving impaired and killing somebody were quite satisfactory. And unfortunately, the Liberal members did not want to increase that. We heard from a number of Canadian groups that they believe this is blatantly unjust, particularly family members that have lost a loved one, to say that a minimum fine or sentence of $1,000 for killing someone is just. I would ask the member representing the Green Party of Canada, does she feel that those mandatory minimums for killing somebody while driving drunk are satisfactory?
The honourable member for Saanich Gulf Islands.
Thank you to my honourable colleague from Langley Aldergrove. I have to approach this on the basis of the impact societally of mandatory minimums. The evidence, overwhelming evidence from people, experts in criminology, is that mandatory minimums don't work as a deterrent, that mandatory minimums have an effect of skewing our judicial system so that a judge has less discretion in perhaps giving more significant penalties. It increases the evidence from other states from the U.S. and in some states, for instance, Texas, they've stopped using mandatory minimums, is that it increases the discretion of a prosecutor to work with a defendant to force a result before it even goes to trial, and in some cases allows a lesser penalty because of the place. And I know my honourable friend from Langley Aldergrove disagrees. I would rather see our courts apply the sentences based on a judge looking at the severity of the crime. I agree that I'm offended when someone who's killed someone while drinking and driving is let off with a light sentence. My disagreement with my friend from Langley Aldergrove is that I don't think mandatory minimum sentences are the solution.
Questions and comments? Question commentaire. The honourable member for Sarnia-Lambton.
Thank you, Mr. Speaker, and I'd like to thank my colleague who always is very thoughtful in these matters. I'm very concerned as well, not just about the random testing, because when we look at traffic fatalities in Canada, we know 16% of them have alcohol-related, 24% are drug-related, and another 18% are a combination of the two. What's really troubling to me is the hypocrisy of legalizing marijuana, which is going to increase the amount of impaired drug driving, when they don't even have a test for impairment. So whether the tests are random or not, there isn't a test for impairment for marijuana. So would the member comment on that?
The honourable member for Saanich Gulf Islands.
Thank you, and I thank my honourable colleague from Sarnia. And the evidence on this one is difficult. You're right. Cannabis is, you're right, excuse me, Mr. Speaker. My honourable friend is correct that cannabis is to be legalized. The evidence is very conflicting as to whether, we certainly do know that intoxication with cannabis and intoxication with alcohol has very different physiological impacts. Testing in blood is different. For instance, blood alcohol levels diminish very much more quickly than residues of cannabis and THC in the system, can be present for days and a person is no longer intoxicated. A person behind the wheel of a car while having ingested cannabis is more likely to drive more slowly. They may not be a safe driver, but they're unlikely to do what people who've been drinking, which we know historically do, which is to drive more recklessly and faster. So the work is being done. I'm satisfied that we will see ways to analyze the intoxication of people who've been ingesting cannabis. I'm more concerned.
Questions and comments. The honourable member for Scarborough-Guildwood.
Thank you, Mr. Speaker, and thank the honourable member for her comments on this bill, which I think are largely constructive, and her amendments actually reflect a legitimate worry. But I take issue with one concern that she has, which is that this legislation will be challenged in the courts. I can virtually guarantee, Mr. Speaker, that this will be challenged in the courts. There's not a scintilla of doubt in my mind that this will be challenged. And I recollect the time when 0.8 was put in the criminal code, and it was challenged every which way from Sunday. So I just would ask the honourable member how supporting or how being concerned about it being challenged in the court should Parliament still not face up to the larger public purpose of putting forward this legislation, and how the courts deal with it is how the courts deal with it.
The honourable member for Saanich Gulf Islands.
Thank you, my colleague from Scarborough-Guildwood. I confess very honestly that this bill has led me to be torn. I've debated myself very strongly. I will vote for it if it's put forward without my amendments. I know that some of the experts before the Justice Committee urged that we not pass it without the amendments. I think the larger public purpose is so significant that the courts may well find that it's constitutional, but they may not. There is that doubt, and I think the bill could have been constructed to ensure that the random nature of roadside screening include reasonable and probable grounds for the randomness, that there be more surrounding this, that a policeman or police personnel having access to breath screening and blood, drug, alcohol analysis at the roadside be enhanced. I agree with all of that. But the question of the randomness, if it's not truly random and it's actually targeting certain marginalized groups, I think that increases the likelihood that it will be overturned in the courts. And that's something that I think we could have addressed with amendments. So on that